This is Dish and Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dish and Dirt, Gary Pickren.
And greetings and welcome back, everyone, to another episode of Dish and Dirt. I'm your often opinionated but rarely wrong host, Gary Pickren, coming to you from the beautiful downtown Columbia, South Carolina offices of Blair, Cato, Pickren, Castelline. This, the first week of December 2025. I hope everyone had a safe and wonderful Thanksgiving. And I would like to open today's show with a quick Thanksgiving of my own, if you wouldn't mind. And it's just to thank everyone for all the support that you've given Dish and Dirt over the years. I think we're entering our 5th year of doing this show, and I really wanted to thank everyone for supporting, listening, and more importantly, sharing our podcast. It never gets old to me to receive an email or even a pat on the back when I see you in person telling us that you like what we're doing here at Blair Cato through Dish and Dirt. Our plan here is to continue to do Dish and Dirt, to continue to provide you the information, knowledge, and education that you need so that you can be the best real estate agent in the market. I got an email this past week before the break from a broker that I did want to share. She's from a market that Blair Cato is not even in yet. And I wanted to share the email because it does speak a lot to what we're doing here. And I'm real happy that she sent it. It says, as a broker, who do I have to go to for guidance? The attorneys at SC Realtors tell me to consult an attorney. Local attorneys, sure, except most small town attorneys are not specialized in one area of the law, such as real estate. So the answers I seek might very well be a crap shot. That's where you come in. I cannot thank you enough for being a constant and always providing tangible, straightforward knowledge on this crazy thing called real estate, and doing so willingly. Keep up the good work, and please continue to break it down like you're not even trying to impress someone. Thanks. Danielle, thank you so much for that. That makes me very happy to receive those types of emails again. And I want to thank everybody here in this holiday season for all the support, listening to Dish and Dirt. Let's keep it going into 2026. Now, let's talk about our show today. The Realtors Association is making news once again. Unfortunately, they made one very good decision and one not so good decision. So today on our show, we are going to break down both of those decisions, and we're going to start with the positive decision, the one good decision they made. And the headline in Inman News last week read, NAR repeals rule requiring membership for MLS access, leaves decision to local. So essentially, to break this down, the National Association of REALTORs had a rule that in order to get access to any of their affiliated MLS systems, you had to be a member, not only the MLS, but also of the NAR. And now what they're doing is saying this is no longer a national rule. This is now going to be a local rule. NAR will not require it. It's up to the local associations to decide whether or not they're going to make you be a member of the association in order to get access to the MLS. NAR said that the change will take effect January 1st, 2026, so basically less than a month, and are the most extensive updates to its MLS handbook in the last 20 years. Now, as y'all know, I have long been a critic of the policy of making a real estate licensee be a member of the association in order to get access to the MLS. In fact, I believe it was one of the top 10 ways that I said NAR could suck less on a podcast I did right after the Sitz and Burnett settlement. I came up with 10 ways that I thought NAR could suck less for its membership, and divesting itself of the MLS put as one of the main ways. And obviously, divestiture starts by not making people be members of the association to get access to this very important tool. Forcing membership into NAR to use the MLS, I have always felt is wrong for multiple reasons. First, the MLS only exists because real estate brokerages, which remember are licensed by the state, not by the association, submit their listings to the MLS. It's sort of like Priceline. Anytime that the airlines and the hotels want to stop offering their listings to Priceline, Priceline is gone. And I remember back in the 90s, at one time, Priceline had a higher value than all of the airlines combined who were feeding it its listings. Without the airlines, there was no Priceline. And it's the same thing here. Without the real estate brokerages pushing their listings into the MLS, there is no MLS. Secondly, NAR is a trade organization. You are not required to be a realtor. I am a massive supporter of the Realtors Association, particularly at the state level and the local level. I think what they do at the state level and the local level is great. And a lot of what they do at NAR is very good. Without NAR, you don't have anybody out there lobbying for you on the national level, keeping you an independent contractor. So keep that in mind. I'm not anti-NAR. I'm very pro-realtor. But at the same time, it is a trade organization, and I don't believe anyone should be forced to be a member of any organization, trade organization whatsoever. In fact, I am not a member of the American Bar Association. I refuse to be a member of the American Bar Association because it has nothing to do with helping lawyers, particularly transaction lawyers like myself. It's a political organization that takes my money and gives it to its political proponents. And therefore, I have no use for it. I do not want to contribute to them because all they're going to do with my money is give it to a political campaign. Now, on a side, I will say, I think NAR does a very good job of not getting mixed up into politics and taking one side over the other. I do believe that they are purple, as they like to say. So that is a good thing about NAR. But you should not have to be a member of a trade organization in order to do your business. 40% of real estate agents, I think the number is right now, are not realtors and apparently don't want to be. And so they should have a right not to be, even though that might be a very bad decision, as I think it is for them practicing not to be a member of the trade organization. That's very important. But they have the right not to be. But most importantly, I think at this point, NAR can ill afford another expensive lawsuit, particularly one where antitrust allegations could easily be made. Now, I know the arguments that no one is forcing you to use the MLS. You don't want to use their MLS, then don't use it. But if you don't have an MLS, that's just nonsense. That's not going to work for any real estate agent. Number one, you can't effectively practice real estate without the main tool, which is the MLS. And there's little to no alternatives to the MLS. Sure, you can put it on Craigslist, eBay, but that's not truly an alternative solution. And using Zillow for that's also not going to be a solution because they can go get other agents. So there is little to no other alternatives if you're not using the MLS. It's either you join the MLS or you can't be successful. The worst thing, however, is it feeds into this belief that everything is set up, made, and maintained in order to prop up NAR. That has been one of the big claims, not only in the lawsuit, but in the organization called AREA, the Association of Real Estate Area Association, whatever that supposed alternative is to NAR. That's one of the main claims that they make, is that NAR does nothing but to try to prop itself up. I don't necessarily say that's true, but this doesn't help at all. It feeds right into that argument. Now, according to Housing Wire, two things are very clear. NAR is pushing for more and more policy enforcement going down to the local level. And that's something we've seen in earlier years in decisions that allowed the local MLSs and associations the freedoms to choose how the multiple listing options for sellers would work and what those policies should be. And so that's really not a bad thing that we push this down to the state level, because real estate is truly local. That's one of the mantras that the Realtors Association has used for years, even in commercials. All real estate is local. So having NAR rules on a national level, particularly when you have different ways that states that do real estate closings. For example, we only have like 7 states that still have lawyers doing closings. We have title companies, you have escrow. And so closings are done completely different state to state. There's so many different ways that real estate is practiced, from broker to broker transactions to no broker to broker compensation transactions. You have transaction brokers down in Florida. You have brokers in North Carolina. You have sales associates in South Carolina. So there's a lot of different ways. So one policy probably doesn't fit for everybody, and it's best to let the local associations, or at least at the state level, make a lot of these decisions. The second thing that's also true is that when it comes to the NAR Code of Ethics, the primary focus on proposed changes has been updating the code so that it better aligns with the business practices changed under the mandated settlement. So those are the two big things that we are seeing. I think Housing Wire is 100% correct there. Let's talk about the particulars in this new change of rules. The effort was essentially done to decrease the risk of future antitrust complaints, both by the federal government and by lawyers like Michael Ketchmark. The organization repealed policy statement 7.7 from the MLS handbook, which states NAR was firmly and unequivocally committed to the principle of requiring membership for access to realtor-affiliated MLS. Access to the MLS instead is now a matter of local discretion. NAR approved various changes to the rules aimed at reinforcing that principle. So what we're seeing now, NAR basically has no principle, guidance, rules on this whatsoever. There is no requirement, no firm statement, no commitment to you having to be a realtor member in order to get access to the realtor affiliated MLSs. Now, keep in mind, not all MLSs are a realtor affiliated. In fact, here in South Carolina, we have this consolidated multiple listing service in Columbia, which is not realtor affiliated. According to MN News, hundreds of thousands of real estate agents can already join MLSs without becoming a realtor. And what we're seeing now as a result of this rule are even more gaining that access. Now, again, local associations make the rules, and they do not have to pass a rule that says no membership required. They can still require membership if they want. I think that's a terrible situation. I'll explain that in just a minute. So now let's take a look at some of the MLSs who have either made the change previously or are making the changes now. Smart MLS, which is one of the nation's largest MLSs, they've already moved forward with providing access to agents who are not NAR members. They said that we have added an MLS-only subscription on October 1st, so they did it even before the vote, at Dorify MLS, which serves most of North Carolina. Canopy MLS, which many of y'all will know in the upstate here in the Carolinas, they say they have been an open MLS since January of 2025, though the group didn't elaborate on any changes that could or have been made. Those MLSs and others who have joined the nation's top 5 MLSs have already provided MLS access to non-realtors. That includes the CRMLS, which is the California Regional Multiple Listing Service. That, in fact, is the nation's second largest by subscriber count, and they have already offered access to non-realtors for decades. In fact, Art Carter, who is the CEO, he told MN News in California, the result of a case from the early 80s, realtor orgs in California have not tied MLS membership to realtor membership, so no changes are going to be necessary. That also is the case for Bright MLS, which is the largest MLS in the nation, and it provides access to non-realtors for higher quarterly fees than realtor members. They said that we removed the realtor membership requirement in 2005, and we allow MLS only. Realtor and non-realtors get the same level of MLS access. So that is interesting to see that most of these had already made that change. The other interesting change that you will see that has also come about in this most recent update is that local MLSs are now in charge of deciding whether to accept open listings or whether they transmit listings to third-party aggregators or display their listings on a public website. And that was according to Atlanta Agent Magazines. So great move by NAR, but does it go far enough? I say don't leave it up to a local rule, just ban it outright. My problem is now that the local associations have the right to require membership, how does it make it any less of an antitrust issue for the Realtors Association? Does it just move the target from NAR on the national level now to the associations on the local level? If it's a bad policy at the national level, why is it a bad policy at the state level, at the local level? Clearly, it's a bad policy. I don't think anybody's arguing about that anymore. I think everybody recognizes requiring membership in NAR or the Realtors Association in general in order to get access is probably an antitrust problem, and it's bad policy. So I don't know why we're going to say, well, if it's local, it's okay, but if it's national, it's not. If it's antitrust doing it across the country, it's still antitrust doing it in Greenville or Spartanburg or Columbia or Charleston or Myrtle Beach. If I was a local MLS, there is absolutely no way I would maintain this rule, because now the target is shifted from NAR to you. If you're an MLS and you still have the rule after this saying, well, we're still going to require membership, I think you're crazy. I think the target is now going to be squarely on your back. I wish NAR would have just completely banned it outright instead of pushing it back to the local associations. Lastly, I don't think it goes far enough because it doesn't completely divest MLS from the association. I will admit that I do not know all the ins and outs of how MLSs work with NAR. I hear conflicting stuff all the time about how NAR makes no money on these. And then I hear, well, they apparently making some money because they wouldn't be doing it otherwise. If they're non-money makers, then why is MLS even tied to NAR? So let's take their argument. We don't have any control and we don't make any money over the MLSs. Then why are you taking on this tremendous liability? The reality of it is, Sitzer and Burnett case arose out of the practices of the MLS, which was allowing you to search for properties based on commission rates. Without that, you probably don't get sued. If their liability is so large for NAR and they're not making any money off of it and have no control of it, why do they have it? Divest themselves of it. Now, again, there must be more to it than I know. No one's ever told me, well, we actually do make money because nobody wants to admit it. But that seems to be what NAR needs to do. So my argument is great move on eliminating the rule, bad move on allowing the locals still to use the rule. They should have outright banned it altogether. And frankly, they should be looking at how to get rid of MLSs altogether. Just let them be privately owned like we have here at CMLS. Now, the not so good look. This is also comes out of the NXT conference in Houston. The National Association of REALTORs, their board of directors, voted in favor of a proposal that would have imposed stronger requirements on realtors to disclose all referral fees involved in a transaction. But shortly after the vote, the group of local delegates, which is known as a delegate body, rejected the proposal. And as a result of the change, the Code of Ethics won't be updated. What is extremely interesting about this vote is the proposed change passed the full NAR board of directors with 84% of the more than 880 members voting in favor of it. Stop right there for a second. Getting 84% of people to agree to anything is impossible. I mean, this is an 80-20 argument all day long, better than 80. It's almost a 90-10 argument. It passed the board of directors, but somehow doesn't pass the delegate body. It didn't get the necessary 2/3 votes from the delegate body to pass. This is a significant rebuke of the wishes of the vast majority of the members of the association. That is not a good look. That is not a good look at all. That board of directors represents the people, the daily in the grind agents. And they say their members, 84% of them said, our members don't want this. We want to disclose. We don't like this lack of transparency. We think it's good that we disclose these referral fees. But yet the delegate body came in and said, no, we don't want more transparency. Now, the proposal would have expanded the requirement for realtors to disclose to clients when they or their companies receive any compensation or fees from the referral. This decision by the delegate body has roundly been criticized, and I think rightfully so. And we're starting to see a lot of associations, a lot of companies implement their own rule in spite of this. In fact, EXP just implemented themselves the disclosure of the referral fees. They did it on their own because the association wouldn't. I want everybody to understand when I say it is not a good decision, I want you to understand it's not because I think everybody has a right to know your financial situation. I get that. Not all professions have to disclose referral fees. However, you are a fiduciary. You're working in a highly regulated federal financial system. So there's that. You're also in a heavily regulated state system. So when you're talking about people's finances, it's going to be highly regulated, whether it's stocks and bonds, whether it's insurance, whether it's the sale of houses. And so you are in a very highly regulated federal financial system where you have statutory fiduciary duties. So when you start talking about that, yeah, there's a disclosure of fees. I'm sorry. I understand y'all don't like that. I'm not saying whether I do or not, but I'm telling you, this is why it's there. When you hear my criticisms and you hear me talking about this, I want you to do this has everything to do with the state of real estate right now and the litigation that's already been won against you, but the litigation that will be to come against you if we don't get our proverbial heads out of our ass. And that's the thing that's happening right now that is beyond frustrating to myself and a lot of people that I talk to that are very high up in this industry, whether it's owners of companies, high-level brokers, people at associations. Same thing that is frustrating me today is frustrating them, and it's this. The most frustrating thing to me is that I go and speak all over the state to real estate agents and brokers. If you need me to come, or associations, I'm happy to come and speak on any topic you want. But every time I get there, I'm asked questions that agents really do not want the answer to. They're just looking for justification. And it's hard to stand up there and tell people the truth. And y'all know from listening to Dish and Dirt, I'm going to tell you like it is, whether you want to hear it or not. And, it's a great way of getting business. I come to your office, I piss off all your agents by telling them what they don't want to hear, and then ask you to send Blair Cato closings. It's wonderful. It's worked for years. The point being is, I'll go to these events and people say, well, talk to me about bonuses. And I say, well, you shouldn't take a bonus. Talk to me about broker to broker. We shouldn't do broker to broker anymore. And they don't want to hear it. They're looking for justification of why they should be able to amend their agreement so they can take that $10,000 builder bonus, which we all know you cannot do. I'm sorry, but you can't do it. The second thing that's frustrating to everybody in this business that sits or Burnett is that we still have this large swath of people who still want it to go back to the way it was. But that ship has long sailed, my friends. I go speak to conferences all the time, and there's always somebody who's been in the business for 40 years and goes, well, I'm just sick and tired of this. We're going to go back the way it was. And I'm like, you're not. We're not going back to the MLS having compensation. In fact, we're probably going to be moving away from broker to broker compensation. All this is changing, and you just got to get on board with it because that ship has already sailed and it ain't coming back to harbor. Victor Lunn, who was speaking to MN News, he's a managing partner of the Wave Group. This is what he said about the decision. Realtors should disclose commissions paid to all brokers agents that are a party to a transaction. The failure to do so is analogous to the Sitzer settlement. When it is not disclosed, the client has no opportunity to negotiate for a service. In many cases, the consumer does not even know that another broker was involved in the transaction. That is horrible for consumers. And it gives me great pleasure to quote Todd Beckstrom, who is from Columbia, South Carolina, is a realtor right here at ERA Wilder Realty. He was quoted in this same article by MN News. When Article 6 was amended in 1999, it may have been reasonable to exclude real estate referral fees from the article of disclosure obligations. Todd Beckstrom, chair of the NAR committee that proposed the change. However, the committee now sees no valid reason to continue this exclusion and believes that clients and customers have the right to be aware of any financial benefits a realtor may receive when recommending products and services. Todd is 100% right. Maybe we can get Todd on the show to talk a little bit more about this in the coming months. One last thing that is also not really immediately clear about what this change would be, which I think might have led to it being voted down, is how would it have applied to lead generating platforms like Zillow, Redfin, and Realtor.com? None of those platforms immediately responded to. I mean, the proposed change comes right on the heels of Zillow being sued for the Flex program, in which that company or that complaint alleges that consumers were quote unquote tricked into working with Zillow agents because they didn't know when they were clicking a button that they were being directed to a Zillow agent who might pay a 40% referral back to Zillow. I've already spoke on this in one of my other podcasts and debunked most of their claims. But is this perhaps why this ultimately failed? Was there pressure from Redfin, Realtor, Zillow, and other lead uh, providing platforms? Was that why the delegates voted against it, because it would affect so many of those programs? We'll never know. Lastly, we had a former guest on Dish and Dirt back during the summer. Her name is Summer Gorlick, and she wrote an incredible piece for Inman where she blasted this entire move. She snarkily wrote this: notably, this development comes from Houston under a big shiny banner declaring a new NAR that is supposedly outrunning irrelevance. That is where the delegate body voted against referral fee disclosure. And I'm going to quote Summer here because I think this was an excellent article. I asked her if she had time to come on, and she said she wouldn't until after the first of the year, so we'll try to get her on after the first of the year. It said the industry has a very real blemish on its record: a verdict, a national settlement, and dozens of lawsuits still moving through the courts. On the flip side, we've been hearing months of messaging about reform, transparency, professionalism, and winning back the public trust. It has felt like a genuine cultural shift was happening, signaling that the thing would be done differently and the entire industry was on board. If you ask me, that's been the rewarding and progressive upshot of all the legal drama and the forced changes, an industry moving toward clarity and disclosure around compensation, a more grounded consumer-first attitude. Her conclusion: some realtors, however, still want to deal from the bottom of the deck. I guess they either don't think they're wrong or they don't expect to get caught. Now, I agree with Summer. I think we have seen a lot of positives coming out of the Sitzer Burnett case. I think getting rid of broker to broker is ultimately going to be one of the best things that ever happened. I think the disclosure has been much better. I think the fact that we're negotiating contracts with buyers and buyer agents and holding the buyers to those contracts and not saying, oh, I'll just get my money from the seller, has been fantastic. Taking it out of the MLS, where agents were offered the opportunity to search closings and offers by commission rates being offered, gets rid of that commission steering issue. I think a lot of this has been very, very good. I don't think Ketchmark had any of these intentions. I think he fell ass backwards into it, but there have been really good things. I would say right now, 70% of real estate agents get it, they're doing it, they're following it, they're moving along. However, I still think there's 30% out there that are still doing workarounds, modifying agreements when they know they can't, accepting bonuses they know they shouldn't be accepting, offering bonuses they know that can never be paid, and doing these workarounds. And the problem is when you start with something about how do I do a workaround, it's saying basically there's a law out there, I don't want to follow it, I'm trying to figure out how to get around it. Now, of the 70% that I believe that are doing it right and following the rules and understanding, there's 10 to 15% that are making the real change in our market. They're reaping the benefits, and the rest are kind of meandering through it. So the question is, how do you become that 10 to 15% that sees these rules, they understand the rules, and they're taking advantage of these rules by not doing broker to broker, not offering the bonuses, getting the buyers signed in with good buyer representation agreements, getting their full worth, explaining what it means to navigate through a transaction. That's where we all should be moving. Unfortunately, as I said, there's still a good swath of agents who don't want to follow the rules, still want to find their workarounds. And unfortunately, there's a lot of people out there telling them, oh, it's fine for you to take these bonuses, amend your buyer agency agreement, knowing that is a 100% in violation of the settlement. So why should you be disclosing this? Well, according to Summer, professionals who collect or pay referral fees should disclose them to the clients. If licensees have an interest in settlement services providers they refer clients to, that should be disclosed as well. No law or code is required to understand what integrity looks like. Amen. This is all about integrity, guys. Disclose how much of your commission is being referred to you or referred out. You know, it might actually help you if your client actually understood that you weren't getting the entire commission because you had to pay a portion of it to a referral. And for God's sakes, how about let's start disclosing on settlement statements how much of your brokerage is being paid for the mortgage services and the title services that are being offered through JVs and all other agreements. But you know what? We know your brokers will never do that, because the second one of them does that, it's going to be a shitstorm from the agency how much these law firms pay out of their title insurance over to the brokerage so that you would refer that closing. And you see how much these mortgage companies get so that you refer them to your brokerage tied in mortgage company so that they can make more money. When you see how much money that is as an agent, and recognize you're getting none of that benefit, zero of that benefit, but yet they still expect you to continue to help the house by sending all these closings to the house preferred vendors. That will create a shitstorm and you'll quit doing it. And when your consumers see it, it'll create another lawsuit. So mark my words, as Summer says here, you don't have to have a law or code, even though I think there is a law and a code that requires that, to show what integrity looks like. But the fact is, with these brokers who are doing this, who are taking compensation from title companies, attorneys, and mortgage companies, they don't want to show the true number to the client. And they sure as hell don't want to show it to you as the agent. Because when you see these numbers and realize all that money's going into the brokerage's pocket and none of it's coming into your pocket, and you're being asked to submit your clients to inferior products to support that, then that's your problem. And you know they're inferior products because they have to pay to get the business. They were the best in the business. They wouldn't have to pay for it. You would send it to them because they're the best. Summer concludes with this: trustworthy representation requires honesty about compensation. In fiduciary states, South Carolina is one, the obligation is even greater. Referral fee disclosure should be standard practice in real estate, and I am far from alone in that belief. Many licensees want the profession to move in this direction. In the post-settlement era, choosing to keep compensation hidden will not age well. Frankly, we've already learned that lesson the hard way. Right on, Summer. So there you have it. 2 decisions by the Realtors Association. One of them okay, one of them bad. Hopefully we'll see some clarity in the year to come, and we might see a little bit more movement away from that. The good news is good brokerages are already jumping on the bandwagon and saying, fine, NAR, you're not going to require disclosure. We will disclose. We're going to start disclosing it, because we recognize it's our necks in the sling. We're the ones who are going to get sued for failure to disclose it. All right. Well, I hope you guys have a great week. I appreciate you listening. I'm glad y'all had a good and safe Thanksgiving, and have a Merry Christmas. And we will be back again next week for another episode of